खूब लड़ी मर्दानी वो तो झांसी वाली रानी थी. Most of us heard this poem back in school. Subhadra Kumari Chauhan wrote it. But she also wrote another poem, Balika Ka Parichay, a poem about mother's joy on the birth of her daughter. Now here is what is fascinating. Recently, Supreme Court began a criminal law judgment with this poem. It was not a judgment about literature or poetry, it was a criminal case. The bench was Justice Sanjay Karol and Justice Prashant Kumar Mishra. The case was Dr. Ramesh versus State of Maharashtra. And the issue was not murder, assault or theft. It was incomplete form in an ultrasound clinic. At first, this sounds strange. How does an incomplete medical form become a criminal case? But this is where Preconception and Prenatal Diagnostic Techniques Act or PCPNDT Act comes in. The law exists to prevent sex selection and protection of unborn girl child. Whenever a pregnant woman undergoes sonography, the clinic is required to maintain what is termed as Form F. Form F is not ordinary paperwork. It records the patient's details such as how many living children she has, the sex of those children, the medical reason for undergoing ultrasound, which must be at least one among the 23 predefined reasons the Act provides for. Apart from this, the referring doctor's details, the patient's declaration that she does not want to determine the sex of the fetus, and the doctor's declaration that the sex was neither detected nor disclosed. In Dr. Ramesh's case, the allegation was that Form F record had blanks, omissions and inconsistencies. Following an inspection of the clinic records, a district civil surgeon found multiple discrepancies in Form F entries and filed a complaint before judicial magistrate alleging contravention of the Act and rules. The magistrate, upon examining the complaint and accompanying material, took cognizance and issued process against the doctor for the alleged offence. Dr. Ramesh then approached Bombay High Court under Section 482 of the CRPC, seeking quashing of the proceedings, but the High Court declined to interfere, holding that allegations disclosed a prima facie case. Aggrieved by this, the doctor carried the matter to Supreme Court. Dr. Ramesh, in his defense, gave 3 submissions. These are only technical mistakes, there is no criminal intention involved, and the civil surgeon was not the appropriate authority to perform audit under this Act. Supreme Court rejected these arguments. Court held that district civil surgeon was properly notified as the appropriate authority under this Act. Court further held that under PCPNDT Act, if the Form F is deficient, inaccurate, it amounts to contravention unless the doctor proves otherwise. So in simple words, a defective Form F creates a rebuttable presumption, not a conviction or an automatic guilt, but this is enough ground for the criminal case to proceed. So the doctor will get opportunity to explain the blanks. He may still show that the omissions were unintended. He may still defend himself at trial, but he cannot stop the prosecution from beginning the trial in first place. Because under this law, Form F is part of audit trail. In many sex selection cases, there may be no witness and no confession. The record may be the only thing that tells the court whether the scan was lawful. As someone from medical field, I understand how documentation can feel very repetitive. But in medical law, documentation is never just paperwork. It protects the patient, it protects the doctor, and under PCPNDT Act, it protects the unborn girl child. That is why the judgment is so important. It travels from a poem about daughter to a blank column in Form F. Because sometimes what is not written on paper becomes the most important piece of evidence in court.